Good morning, everyone. It is now 10 a.m. We're going to go ahead and get started on an emotional support animals webinar. Just a couple housekeeping items. To avoid disruptions, all participants will be muted and the ability to join with video will be disabled at all times. At the end of this webinar, you will be receiving a copy of the presentation and a recording of the actual webinar itself via email, and it will be available on VestaPropertyServices.com website. At the end of this webinar, the presenter will go ahead and take questions if time will allow for that method. And if you have any questions, at the bottom of your screen, you're going to see a Q&A button located on the Zoom toolbar. It's either going to be in the bottom or the top of your screen. And within that feature, you'll go ahead and ask any questions to the presenters. On behalf of Vesta Property Services and Raphael Law, we thank you so much for taking time today on a Tuesday at 10 a.m. and we'll go ahead and get started. We're going to go ahead and begin with Koch, with the general manager from the Hollywood office.
Good morning, everybody. My name is Jill Koch. I'm the general manager of the Hollywood office, as Sebastian just said. Our Hollywood office currently services 56 properties, which is a little more than 4,000 homes. We recently were acquired by Vesta in December, so we're still in our honeymoon phase. But it is great to be here with you guys, and it is wonderful to teach you and to discuss emotional support animals with Lindsay.
Good morning, everyone. Thank you so much for joining us today. I'm excited to be here and hopefully can answer all, if not most, of your questions regarding the topic today, which I'm primarily really going to focus on emotional support animals because those tend to be the predominant issues that come up at more than service animals, actually. So that will be our focus today. I have been practicing association law since 2003, so I believe I'm going on 19 years. My practice since 2003, for the most part, has been completely focused on condo and HOA law. I predominantly represent associations. I, from time to time, will represent owners, depending on what the issue is. And I'm really excited to be here with all of you today. So, Jill, I guess I'm just going to start. I'm trying to move this so I can look at the screen. Okay. Sorry guys, I'm just having an issue with my screen. What's going on here? Maybe that'll help. Okay. So July of 2020, and in general, it's July 1st of every year. You will see new laws, if there are any passed by the legislature, that come on affecting HOAs and condos. This last July, Florida enacted a new law to clarify emotional support animals. And if you are here today listening to this, it's probably been because you've had at least one issue come up with this. Really, what's been the hardest part in the past has been that there's really been no legal guidance on what's required to show if you have an emotional support animal, what the association can really ask for, what those boundaries are. So that is what the legislature intended to do when they passed the July 2020 new law. And it also addresses individuals who think that they could go online and get a card or get a vest, and that, excuse me, that would be sufficient for being able to show that you have an emotional support animal. We can go to the next screen. Okay, so pretty much what we're dealing with here are individuals with disabilities, emotional support animals, service animals, and what the difference is between those. The first thing is that the person has to have a disability. And then an emotional support animal is an animal that pretty much does what it says it's going to do. It doesn't require any training. They don't perform any tasks. they're simply therapeutic. They make you feel warm and comfy. And by having them, it alleviates one or more symptoms or effects of a person's disability. Examples of a disability can be anxiety, sleep issues. I mainly see anxiety and sleep issues the most. A service animal is different. It is specifically trained to perform a task for the individual with a disability, including physical, sensory, psychiatric, intellectual, or other mental disabilities. The work or task performed must be directly related to the individual's disability, and they may include giving guidance to someone who's blind, alerting an individual who is deaf, pulling a wheelchair, assisting with the mobility of balance, alerting and protecting an individual who's having a seizure, retrieving objects, all different types of disabilities. A service animal is not a pet, so it's very important that if a board is engaging in conversations with someone who says that they have an emotional support animal or service animal, I highly recommend that you do not call it a pet. I had an instance the last week, an owner who actually retained me, where the association had made quite inappropriate comments during an interview. Hopefully none of you are on here today, or maybe hopefully you are on here today, where the person came in, has a disability, and the board member's response was, if it has 4 legs and it barks, it's a pet. You could get sued for discrimination for that. It seems very harmless to make a comment like that. But for someone who has a disability, that certainly can be viewed as discriminatory. It is not a pet. They are either emotional support animals or service animals who perform work. On the flip side, it is also very important, if you are the person who is trying to get your service animal or emotional support animal approved, that you also do not refer to it as a pet, because right there is usually a red flag that the animal may be fraudulently being passed off as something that it's not. The biggest difference between an emotional support animal and a service animal is that one is trained to perform a certain task and one is not. The relevant laws when it comes to what applies to service animal, emotional support animals is, one, in general, the fair housing laws. There are HUD guidelines. HUD guidelines are not laws, but many states look at the HUD guidelines and use that in preparing what is going to be the state's laws. Section 413.08 of the Florida statute is the service animal statute, and section 760.27 of the Florida statutes is the emotional support animal. It is unlawful to discriminate in the provision of housing to a person with a disability or disability-related need, and who at any time obtains an emotional support animal. So pretty much, if you have a prospective buyer or a tenant has an emotional support animal, at any point in time obtains an emotional support animal, you cannot discriminate on this basis. And what I mean by that is this. Maybe 2 weeks ago, the person didn't have anything that they need, and it seems very suspect that they now all of a sudden have a doctor's note that hits all the right requirements in order to be able to get that animal approved. You really cannot base whether this person has, if they have everything that they need, I highly recommend that the board decide not to play doctor here. Because the way fair housing looks at it is, if a doctor was willing to write a note and the note has all the components that it has to have, who is the board to be in a position to have an opinion other than the doctor? And I actually had a crazy situation come up like this. I represented an association. I had inherited an issue that another attorney it had been a very bad situation by the time it got to me. But someone had been living in the association for over 10 years as a renter. They had a very little dog, had actually said to the association in email many times that he did not have a disability, that it was just his dog, and it was a no pet building. Well, that seems pretty easy. in that sense, you go ahead and you deny the dog. The person has made very clear they don't have a disability. It was very obvious to me when I met the dog that the dog was not a trained service animal. Trained service animals would not be jumping up on people and going over to people to be pet. They are work dogs. They are trained generally between 18 and 24 months in rigorous training. They are the best behaved dogs you will ever see. So when this dog ran out of the elevator to greet me and jump up on my leg, I knew the animal was not a service animal. But despite all that, when we had arbitration with essentially the DBPR, it was Fair Housing and Human Resources, at some point he got a letter and he figured out that in order to be able to keep this dog, he was going to have to get a doctor's note, despite the 30 emails of him telling us that he didn't need it. It's the way that Fair Housing looked at it. It doesn't matter. Maybe he didn't need it 2 weeks ago, but he has the note now and you can't deny it. So even though every step of the way he said he didn't have a disability, Fair Housing ruled that the association discriminated and he was required to have that animal. In my mind, that was an insane, crazy ruling. The fines that they threatened to impose them with were $900,000. It was just insane. But the reason why I mention this is because it goes to show you that even though common sense wise, you may have a situation where you think that someone is lying or using this as an excuse and that they moved in without disclosing it to you, they filled out an application without telling you, that all may be true. But as soon as the doctor sends the note, if it has all the magic language, a good attorney is probably going to tell you it is not worth the risk of a discrimination suit. It would be extremely expensive. They tend to side on the side of the complainant. And as long as they have the documentation, the Health and Human Resources, which handles these fair housing claims, is likely going to side with the doctor and the complainant and not the board. Okay, so that was my little story about that. What can an association request from a person asking for an accommodation with an emotional support animal? If the disability is not readily apparent, so a person isn't blind, person isn't, something on the outside that you visually see that you can see that there is an issue, you are allowed to ask for reliable information that reasonably supports that the person has a disability. Okay, you are not entitled to medical records. You are not entitled to review medical records. If the person wants to give you their medical records, they certainly can, but they are not required to do so, and you are not allowed to ask for them. So some supporting information could be a determination of disability from federal, state, or local government agency, a receipt of disability benefits from a federal, state, or local government agency, proof of eligibility for housing assistance or a housing voucher received because of that disability, information, and this is the one that most people get, information from a qualified healthcare practitioner, a telehealth provider. So understand, a doctor over the phone can prescribe these, or any similarly licensed or certified practitioner or provider in good standing with his or her profession's regulatory body in another state, but only if such out-of-state practitioner has provided in-person care services to this tenant or the person who's requesting assistance. Such information is reliable if the practitioner or provider has personal knowledge of the person's disability and acting within the scope of practice. So the person does not have to be a psychiatrist. The person does not have to be a psychologist. It can be a cardiologist. It can be a telehealth provider. It can be, it essentially can be any healthcare provider, as long as the person is familiar with the person's disability, is licensed, and in good standing.
Hey, Lindsay.
Yeah.
Can a board member decide that the information provided by the doctor is sufficient or not sufficient?
I mean, this is where you start getting into issues. I mean, I would say you are not a doctor. If the doctor's note hits all the requirements, so requirements being that the note says that they are personally familiar, that they have been treating this person. If the doctor really is a licensed doctor and in good standing, in this letter says that the person has a disability. They don't have to go into details about the disability, but normally it has to say like, you know, it's anxiety or sleep disorder, or, you know, give some kind of information that allows you to determine that there's a disability. And then you also have to show that that disability affects one or more major life activities. So that could be walking, talking, sleeping, eating. And that the use of this animal alleviates or helps with those major life activities and allows the person to be able to utilize the home. Those are the magic terms. If those are in there, I would highly, highly caution the board, and definitely don't do anything without calling legal counsel. I don't care. Like if you have this person, like, you know, like a personal injury, like, you know, the person gets out of the car and takes the neck brace off and you think that you have the smoking gun, you do not deny someone without calling your attorney, because you are likely to get sued. Now, you may get lucky and you may have someone who just decides to move on to the next building and isn't litigious and doesn't want to get into a fight. I have some boards that may push the envelope a little bit, where we give a little bit of pushback and ask for a little more information. But you have to be careful. I would tell you if at that point you get a response from an attorney on the other side, that's obviously a red flag. And two, there is case law out there that says you cannot ask for the same thing, even if you ask for it in different ways, over and over and over again, because that actually can be considered a denial. Okay. So you have to be really careful. Like if you're asking for something else, it better, you can't ask the same question 10 different ways, essentially. Okay. is what that law states. Does that answer the question?
Yeah.
I know that this is really frustrating. Unfortunately, as a board, you don't have a lot of, I don't want to say control, but there's not a ton of wiggle room here, unless you're not afraid of the consequences. If you're an association that doesn't care if you get sued and, you know, you want to push the envelope, then certainly that's a decision that the board can make. I have clients that don't listen to me. But I do caution you that it can be very expensive. So you cannot request any information that discloses the diagnosis or severity of the person's disability or medical records, which we already talked about. Something else that's very common that comes up is, can someone have more than one emotional support animal? I would tell you that a year ago, my answer was, maybe. There is nothing that really says if you can have more than one. But now with the new law, it kind of addresses it. It says that if a person requests to keep more than one emotional support animal, so that, you know, obviously hints that someone can have more than one, the association can request information regarding the specifics for each animal. So you would need a doctor's note for each animal. Sorry, my automatic lights go off every once in a while. The association is allowed to have an application process, okay? But again, you have to be careful. I don't have a problem in general if an association wants to mainstream the process, because to some extent, by having a process in place that everyone follows, it reduces the risk of a claim of selective enforcement, because every single application, all of the requirements are all the same. However, if someone truly has a disability and does not fill out your application and does not comply with your process, that will not be a reason that you can deny someone. So you can have a process, but if the person truly has a disability, that is not going to be a reason that you can deny the request. Now, there are exceptions to what the association can do when someone has an ESA or a service animal. And by that, a very common question is, well, we have a declaration that says you can't have pets over 40 pounds. We have a pet deposit. We have breed restrictions. Well, you're right. You may have restrictive covenants that state that you can't have a dog over 40 pounds. You can't have more than 2 dogs in the unit. I'm just saying dogs because let's be honest, I doubt any of you have ever had a miniature pony request. So we'll just use the most common.
However, Lindsay, we do have a question that says, does this also stand for ESAs for cats, monkeys, snakes, etc.? Can people get an ESA for other animals?
It's not limited to dogs. I don't know about snakes. I mean, in general, it isn't uncommon, especially with service animals, miniature ponies, potbelly pigs. I mean, it depends. You'd have to look on it on a case-by-case basis. There could be local ordinances. I actually argued a really fun, interesting case that I won up in Vero Beach with emotional support animal chickens. And my client had a she was a 10-year-old little girl who had extreme allergies. She couldn't even go to school because she couldn't touch a desk that was cleaned with any type of cleaning product, or she'd be in the hospital. She had a very low immune system. Even something that's organic is not actually truly organic. Sometimes there still are, low level of pesticides and stuff like that. So she needed in her backyard organic soil, her own chickens so that she could eat eggs because she couldn't eat any store-bought chickens, eggs, even organic. She had to grow all her own fruits, all her own vegetables. She could not touch anything that was not in that clean soil. And the association wanted her to remove the chickens. We obviously argued that the chickens were necessary, that this was a health issue for her. The association, believe it or not, fought us tooth and nail, and we won. She was able to keep the chickens, not even through going to college. As long as she was alive and her parents lived in that neighborhood, they were allowed to make sure that they had that food source for her. So yeah, it doesn't only need to be a dog, but I would tell you that I'm not giving you specific legal advice. That doesn't mean there can't be an exception where a chicken wouldn't be allowed. There are ordinances. The cities and counties also have to grant disability exceptions. So you really would have to discuss with your attorney the specifics. But what you can't do is you cannot charge a pet deposit. You cannot require someone to use a different elevator. You can't require that they go in through a separate entrance with that animal. You can not enforce your breed restrictions. So someone has a pit bull that is a service animal or emotional support animal, as long as the dog is not aggressive, hasn't bit anyone, hasn't shown signs of that kind of behavior, you're likely going to have to approve that animal. And the same with height restrictions. So you can't impose any of those types of requirements, even if you impose it on other people in the building, if it is an emotional support animal or service animal. Now, there are exceptions, okay?
What if you're at the pool? The ESA is allowed to go to the pool? You can't ban them from common areas?
Yep, they could go anywhere on the property that the person with the disability is allowed to go. However, the key is the person with the disability. So let's just say you have a husband and wife. Wife is the one with the disability. Husband can't go to the pool with the animal. Wife can go to the pool with the animal. The animal is specific to the person with the disability. Person dies, person moves out, they get divorced, whatever it is. Once that disability is removed from the building, the right to have that animal, especially, if it's in violation of the restrictive covenants, also goes away.
Okay.
Now, there are exceptions to this, okay? The dog cannot be aggressive or threatening, and the statute also makes this clear. I will tell you that if you run into a situation with any animal in your building, okay, not just an emotional support animal or service animal, and a dog snaps, bites someone, shows aggressive behavior, you better get a violation letter out really quick, because if the board is aware of the aggressive behavior and someone gets hurt, I guarantee you someone's going to say that the board was negligent. I will also tell you that I am not an attorney that heavily tells my clients, you need to litigate, you need to litigate. I'm not afraid to litigate. But I think that there's a time and place, and I won't just recommend that for purposes of you spending a lot of money. When you have an aggressive animal situation, I will tell you that if someone gets bit or there is a serious problem, you better do everything you can to have that animal removed, including filing an injunction to have that dog removed, even if you know that you may not win. So that if someone gets hurt on the property, you can at least say you did everything and anything that you possibly could do to have this animal removed, and a judge turned you down. Because at that point, there's nothing you can do. You've taken it to the limit that you could take it. But at least in that point, they can't say that the association was negligent in how they handled that aggressive or threatening behavior. And again, you want to discuss that with your attorney. There may be attorneys that have a different opinion of mine, but sometimes you litigate and you make the decision based on whether you can win or not. Okay. I'd say that that's probably 98% of the time, but then sometimes you need to go that route so that you can absolve yourself from liability should someone get hurt. Also, if the animal is a nuisance, if the dog barks uncontrollably and you have multiple people in the building complaining, dog is urinating, defecating, in the elevator all over the common elements, the person refuses to pick up after their dog. Also, emotional support animals are required to be tethered. By that, I mean it has to be on a leash. Leash is not supposed to be longer than 6 feet. The only exception to that is if someone has a service animal and the dog can't perform its job while being on a leash, then there's an exception to the leash. I've never seen that in any of my associations. Doesn't mean it can't happen, but that's a rare exception. In general, not complying with other provisions of the documents. So those are circumstances that you can have the animal removed from the property, where the person can't just say, I have an emotional support animal, I can do whatever I want. If you lie about needing an emotional support animal, there are penalties for that. I believe it's a misdemeanor. I'd have to look at that. I don't remember what the criminal penalty is, but there actually is one. Same with the service animal for fraudulently trying to say you need one if you don't have one. What's my next thing on here? Some of this I already addressed. ESA registration of any kind, including identification cards, patches, certificates, similar registration from the internet is not by itself sufficient information to reliably establish the person has a disability. I think I touched upon that earlier. The key here is really going to be getting the doctor's note. I unfortunately had this situation come up last week where I had a client that did have a doctor's note. Association didn't like the way it read and the doctor refused to revise it. At the end of the day, the doctor is going to write what the doctor is comfortable with. There may be attorneys that can help guide, but the key is, and I'm not a doctor, so I'm not going to tell you exactly what the letter is going to say, but like I mentioned earlier, the key is it has to establish a disability. The disability has to impact one or more major life activities. Those words should be in that letter. The letter needs to show how those major life activities are better because the animal is there. And it needs to show that the physician who is recommending or writing the prescription, we also refer to them as prescription pets, has personal knowledge of this person's disability. Those are essentially, the magic language. Like I said, I'd be very careful in denials. If you get a request, if you're not, I mean, I would say any request goes to your attorney. Just so that you can also make sure that you're not approving something that's not accurate either. You definitely want to make sure you document the files appropriately. So that's pretty much it. You know, there's a lot of literature on there out there on this out there. Unfortunately, this happens to be one of those areas where sometimes there's not a definitive answer. There's nothing that says that this is exactly what you need. So there's a lot of subjective opinions out there about, you know, what's acceptable and what's not. One thing that is clear is you can't discriminate, you can't selectively enforce, and you better be careful if you have a doctor's note that hits those elements.
So Lindsay, is it your recommendation that you set out a policy about the ECAs and maybe an some sort of documentation to make sure that everyone stays in the same guidelines when applying for ECA? I mean, we are in a world where more and more people are getting ECA animals because they know they can.
I'd say it depends. If you are an association that really doesn't like animals and you are a no pet building and you want to make it harder for people to figure out how to do it right, then I would say you might not want an application process, because an application process is going to set forth exactly what is necessary for someone to get that animal. Okay, so they're more likely to know exactly what you need and provide it. If you are an association or a board that, even if you're no pet building, that doesn't really have an issue with approving them, but just wants to make sure that you're documenting the file right, well, then I would say an application process is good. It lets the person know exactly what they need. I think it definitely cuts down on selective enforcement, because everyone goes through the same process. Everyone has to supply the same information. The file is documented properly. So really, it's strategy. It totally depends on the association. I have lots of associations. I've done a ton of these applications, but I've had associations come to me and they've been like, we do not want animals, period. And when that's the case, I'm like, well, then I probably wouldn't do an application, because you're just helping someone be able to figure out how to do it, and you're gonna have to approve it.
So what if you live in a no pet building and a visitor comes, a visitor of the resident, and they have an ECA animal? What consideration do they owe the guest compared to a resident?
That's a really good question. I mean, I would say to some extent it would be, I mean, the discrimination part is a housing provider. I'm not sure if in the condo and HOA setting it applies to guests, but at a minimum, I would say they would need a doctor's note too. I mean, if an owner has to go through that process to be allowed, a guest certainly, I do not think, would have a less rigorous process. And that would not be able to happen like when the person just rolls up with the animal.
Right.
There might be something out there. I mean, with a service animal, you know, if someone is blind, I would tell you that you're probably going to have to let a service animal in, because the person probably can't use the property without it, especially if the disability is visible. But I would tell you, if it's a no pet building, then that means no pets. And if someone has a disability, they need to go through this same process. I honestly would have to look and see if guests have the same protections, because that's one of those things that it seems like it's something that would come up often, but I've actually never really had that come up, that specific question on any of my properties, which is.
But if you're a renter, you have to go through the same policy with an ECA. The building cannot deny a renter of having an ECA.
No, but I will tell you that an association can have restrictions that allow owners to have pets and not allow renters to have pets. That is allowed. It seems like selective enforcement, But you're treating all the renters similarly, and they are different than the owners, believe it or not. I know that seems discriminatory, but there can be different rules for renters than owners. However, again, if the person has an emotional support animal or service animal, the tenant would go through the same process as the owner, and it would have to be approved.
Okay. Now, is it okay to post a no pets allowed in the pool area, according in Palm Beach County? Or, I mean, if they're an ECA,
I don't see why not, but just understand if someone has an approved service animal or emotional support animal, there may be exceptions. Maybe you want your sign to say no pets allowed in, no pets allowed in the area, or, unless, a service animal or emotional support animal. I mean, there may be ways to put something on the sign that makes it clear to people, but then again, you're kind of giving away that there may be exceptions.
now we talked a few minutes ago about an ECA animal being allowed at the pool if they're with their approved owner, right? Now, that doesn't mean that they're allowed to access the pool, right? Like the dog cannot go in the pool with them because they're an ECA animal.
I mean, I do think that there are health restrictions on that. I don't know if the county or city waives any of those health restrictions. That's a tough one. It's obviously a sanitary issue. But if someone needs a service animal, like they physically can't go in the pool without the dog, I don't know, there may be some type of exception to that. That's one of those things that, again, like on a case-by-case basis, the attorney would research to tell you if there's an exception for that.
Okay.
Depending on what depending on what the disability is too.
Right.
If someone has problems sleeping, why do they need the dog in the pool? Has nothing to do with the disability.
Okay. I guess if someone is fear-filled that they're going to drown, that's a different situation.
I don't know if a phobia like that would be considered a disability. I guess,
Okay.
Something really extreme possibly could be, but that would be for a doctor to determine.
Right. Now, this person was told that a board or a manager can ask a person to change different kinds of animals, smaller to maybe a smaller animal. Is that true?
Nope. Well, not if it's an emotional support animal or a service animal. They are not subject to breed or height restrictions.
Okay. Does the ESA animal have to physically be with the handler for 24 hours a day?
No, I will tell you, if it is a true service animal, it probably would be, because that animal is supposed to be working, and obviously someone's disability, can happen at any time. Emotional support animals, I mean, no, there's nothing in the statute that says that. And there's nothing that gives the board the right to determine whether someone has a legitimate disability or not based on that. So, these are the parts that are hard, because unfortunately the statute does not take into account anything. And that is why my general rule, and it may be a little more, what's the word I'm looking for? Not as conservative as some attorneys. I mean, I can be conservative on it. If the board is like, nope, we don't want to do it. I mean, I've been in that situation where I've had to, be harder on the person. But in general, if I see a note and it has what I like to call the magic language, my discussion with the association is going to be, you're taking a real risk here if you deny this. The note says what it says. You are not a doctor. You are not in a position. You are not in a better position than the doctor, essentially, to determine if this animal is needed or not. And that is how Florida's human resources will look at it as well.
Okay. What if your liability insurance prohibits certain types of animals?
That is a good question.
Yeah, I've actually never seen insurance limit in breeds.
You may have to talk to your insurance carrier about that, but or you may need to get new insurance. But, you know, I mean, I don't think that there's certainly in the statute is no exception that says that you can deny because your insurance doesn't allow it.
Right.
So I would say, like everything else, the disability essentially conquers the restrictions.
A person in our community has an emotional support animal that
Oh,
barks.
by the way, let me back up for a second. I would say maybe in a situation like that, that would certainly be something you'd want to know.
Right.
You should contact your agent and see if there's an exception for service animals and emotional support animals, and see if you can have that written into your policy.
Okay. A person in our community has an emotional support animal that barks all day and is a nuisance to the neighbors, and we would like to have the dog removed from the community. The person is also a minority, handicapped, and LGBTQ. Is she or he offered any additional right, or they, excuse me, it offered any additional rights to keep this animal on property by law?
I'm going to say that you're probably going to have a problem. You have multiple possible discrimination claims going on there. However, the statute is clear that if an animal is a nuisance, the association can have the animal removed. I would tell you that you better have more than one person complaining. They better complain in writing. You should have sent multiple letters to that person letting them know that there have been complaints that the animal is a nuisance, and if they can't get the animal, you know, to stop being a nuisance, that the animal may be permanently removed. I'm going to tell you, before you do anything, you need to turn it over to your attorney. Your attorney should probably also send a letter, and then the attorney should also look at your documents. Hopefully, if you're an association that has pets, that allows pets in your building, hopefully the attorney that drafted those documents drafted some kind of language that does give the association the right to get an injunction, to have the animal permanently removed if they're a nuisance or a problem, and get a return of legal fees for that. So you need to look at the statute, you need to look at the documents, but I would say that should go to the association's attorney.
Okay.
And
Now,
yes, it is possible to have an animal removed for a nuisance, even if it's a service animal, emotional support animal. I guess that's the short answer.
now, how do you handle residents that verbally attack an ESA owner within the community? That's sad.
I mean, I would say to some extent that the association is not necessarily responsible for someone's behavior, but I would say that that is nuisance behavior as well. And if someone reported that to the association, I mean, to some extent, that's an owner-to-owner issue. I would probably tell the association to send a violation letter letting that person know that, you know, they don't have the right to talk to anyone like that in this building, and they consider that to be nuisance behavior, and it won't be tolerated. There is some literature out there. I have not seen it enforced, but there is some literature out there that talks about if people are harassing in the building and the association's aware of it and doesn't step in, that the association can kind of be tagged for that harassment. I haven't seen it enforced. I threatened it myself a few weeks ago on another matter I have. I don't know that I would be successful on it if I was to sue. I think it's, you know, how much is the association really responsible for someone's behavior, especially when it doesn't have anything to do with the association. But I would still say that it would be appropriate for the associate, if someone reports it, to let that person know that this is an approved emotional support animal, or assuming that the individual is okay with this, that has a disability, or service animal, and we caution you, you know, your behavior could be considered discriminatory, and we're demanding that, you know, you cease and desist.
Right. Since our COA has a dog limit of 30 pounds, can we ask owners of an ECA to wear a vest to differ, or to have an ECA wear a vest to differentiate them?
I assume by COA they mean declaration.
I'm assuming it's a HOA or condo association. either,
Okay. I'm just gonna assume it's in the restrictive covenants in the declaration.
correct.
I mean, there's nothing that requires someone to do that. So, I mean, you'd be asking them, essentially what you do is you want that person's animal to stand out so that people know this is why it's allowed to be that exception. You certainly can ask if the person refuses to do so. I don't think that you can require it. There's nothing that requires them to have that. And if anything, the law is clear that having that does not make your animal an emotional support animal or service animal, that on its own is not sufficient.
Okay. I'm going to hold off on the next question because I'm not understanding it. So before I ask it, I'm going to process it. What can you do if a person has an animal and just refuses to give you a doctor's letter?
Well, I mean, in that case, I would probably say that the association is not in a position to grant an approval because the required documentation has not been provided. And if it's a no pet building, I'd probably tell the person they have to remove the animal.
Okay. Does a guest of the homeowner need to inform the board if the guest bought an emotional support pet and plans to stay 1 month in the community?
Okay. Well, let's back up a second because there's like a few things here.
Yeah.
First of all, you need to look at your documents because sometimes there are rules that say that any person staying in a unit for more than a certain amount of time is actually considered a tenant and not a guest. So that's important because there may be a whole nother approval process, especially if the owner of the unit is not residing in the unit with the guest. Typically, for someone to be a guest, the owner has to be there with the person as well. So that's number one. You're going to have to decide, is the person a guest, is the person a tenant? Two, I would tell you, if it is a no pet building, and let's just say you're allowed to have a guest for 30 days, I would say that the guest has to go through the same process as a tenant or an owner. They need to provide a doctor's note and go through that process. Now, whether the association has the right to flat out deny a guest, like I said earlier, I'm sorry, that is something that I would have to specifically research for a client.
Okay. So if you're going through the interview, and during the interview you found out that the buyer or tenant has an ESA animal, but does not give you any documentation for during the interview, but the person interviewing says no problem, does that invalidate the right to ask for the information later?
What do you mean says no problem?
So
Like approves the animal right there and then?
Correct.
Okay, so let's be clear, okay? I don't know how many people on here are managers or board members or presidents, but no one of you have the right to make a decision without the rest of the board. So let's just say that. I don't care if you're the president of your association, you do not have the right to approve something without it going through the board and without getting a majority vote. Now, the problem is that there are a lot of associations out there that think that they can just approve and anything they want, because I'll keep my comments to myself, I guess, in that area. But understand the problem with that becomes an apparent authority. So then the question becomes, was it reasonable for the person to think that the person who was interviewing them had that kind of approval? So I think it is really important in your association that it is clear, whoever's sitting in those interviews does not have the right there and then to approve anything. What's supposed to be happening is a screening, and then you're supposed to go back and decide if you're giving this approval. And that depends on whether your associations have approval rights. I can't tell you how many associations try to approve or deny people without having that right in the declaration. And just having it in the rules and regulations might not be specific. So you better make sure what those rights are. I would also tell you that, listen, if there's an approval that goes out by the association by mistake and it's in writing, yeah, you're probably going to be bound by that. You probably can't rescind that. So I would just tell your people, whoever's in those interviews, if it's something like that comes up, unless that person through a resolution has been given the authority to approve those things right there and then, they shouldn't be approving anything. And I would tell you that if someone who's interviewing at that point, is looking for that you should tell them that verbal is not enforceable. All approvals are in writing. I would make sure that's in your applications as well.
Well, I guess that's a whole nother meeting, a whole different day as interviews, but we'll stick with dogs right now. Our association forbids German Shepherds, Rottweilers,
Aggressive breed.
yeah. We have an owner who has a Rottweiler as an emotional support dog. The dog is very old and he plans to replace the dog with another Rottweiler. How can we get him to align with the policy of the new dog?
Well, is it an emotional support animal or a service animal?
The first one is per the email.
Okay. If the Rottweiler is an emotional support animal, like I said before, breed restrictions are not enforceable. So if you have a list of aggressive dogs that can't be in the building and it is an approved emotional support animal, they can have a Rottweiler. If that dog passes away and the person still has a disability and goes through the emotional support animal process, you're going to have to approve the animal, even if it's a Rottweiler. If it's just an animal in the building, we'll call it a pet, and there's no emotional support or service animal, then no, they'd have to comply with the breed restrictions.
Now, does the animal, the ESA animal, have to recertify every year?
No, there's no certification.
Okay.
Because it's not like a service animal, and even service animals don't have to do that. But I would tell you, and I think I mentioned this before, if the disability goes away, and it's going to be very hard for you to know, and let's be honest, okay? If someone has a dog or an animal, and even if, let's say that the initial disability goes away, they're going to have an emotional disability with getting rid of that pet or that service animal or emotional support animal. So I think at that point, you kind of need to assume that once you've approved that animal, as long as that person is living in that building, that animal is approved. I mean, unless like the disability is like a functional one that's temporary, if they give you any kind of like mental, I mean, I'll look at it this way. Let's say that I had an emotional support animal and it was, I had trouble sleeping, and now I don't have trouble sleeping anymore. It would be very easy for me to say the thought of giving away my animal gives me anxiety. Well, there you go. You have another emotional support reason. So, you know, I think that you need to realize that once that animal's in the building, it's probably going to be pretty hard to get the animal out unless there's some kind of violation.
Now,
By the way,
but
that's just common.
Let's talk about the violation. So what if the support animal has been aggressive?
Well, like I said before, aggressive behavior is an exception to being allowed to have the animal. So if you've seen the animal be aggressive, the animal's tried to bite another dog, animal's tried to bite a person, and I'm not just talking like a bark, because there are non-aggressive animals that bark. That's how they communicate. But from an aggressive standpoint, I mean, if the animal's aggressive, that's an exception. You can move forward with having the animal removed.
Okay. Now, what if a homeowner buys an animal, right? They call, like, I'm not saying buy. What if a homeowner adopts an animal and they call and they ask, the adoption agency asks if they are permitted for an animal, and you say it has to be within certain parameters, right? And now the homeowner is saying it's an ESA animal, but they don't want to provide any documentation. Can you require the documentation to be produced? Okay.
So I don't have an issue if you, and you're right, some adoption agencies will call the condos. It usually happens in a condo because not a lot of HOAs have these types of restrictions, but in a condo setting, they will call because they don't want the animal to go to a home for the animal just to end up coming back and not, and you know, kind of being like, you know, a yo-yo. So let's say they call and they ask. I think the association needs to say what the restrictions are.
Right.
If the person then submits a reasonable accommodation request by either sending a letter or an application or something saying, I'm planning on adopting this animal, or I adopted this animal and I'm requesting a reasonable accommodation as an emotional support animal, enclosed is my note, and it again has everything it needs to have, then the association would most likely approve that animal. If the person gets the animal anyway and says, well, it's an emotional support animal and I refuse to give you a doctor's note and I refuse to give you any documentation, then I would say that they haven't provided the association with the association needs in order to determine if this animal should be approved or not. I would probably take the position that the animal cannot be approved until that paperwork is turned in. But again, I cannot stress, that is not something that you should do, Jill. That is not something that any of your managers should do. That is not something that the board should do. Anytime there is a denial, even if it seems like it's not going to be a problem, anytime there is a request, it should go straight to the attorney. You do not mess around with these.
Right. So, we have 3 more questions, Lindsay. What if a non-deeded resident in an HOA property says that the support animal is his, not the owner's? Resident claims 2 support animals and 1 pet dog, but the owner is never with the dog.
I mean, if the person's living in the building, regardless of whether the person's an owner or a tenant or an occupant or a boyfriend, a girl, whatever it is, I mean, they're entitled to this same rights as far as if they have a disability, they're entitled to an emotional support animal, service animal, as long as they provide the proper documentation. What was the last part of your question?
That was it.
No. Oh, okay. I thought there was something else in there, I thought. Okay.
Assuming the resident has provided all the proper documentation, regardless whether is it a service or support animal, can the association require a checklist to be filled out by the doctor if the service animal is required in certain areas of the facility? For example, in the pool, the gym, the office.
Yeah.
Also, if the office personnel has severe allergy to animals, what is the association's recourse?
Allergies and fear, because I get that one a lot too. I mean, essentially, the emotional support animal comes above all else, whether someone has allergies, whether someone has a fear. That is not a reason not to approve the animal. You are not allowed to dictate where the animal goes and doesn't go in the building. Oh, that was the other question. And what happens if the animal isn't with them for 24 hours? I mean, there's nothing that says that the animal has to be with them for 24 hours. I mean, someone's disability can be, a sleep issue. It's a sleep issue. The animal doesn't have to go to the pool with them. So I don't think that you could judge it based on whether the animal is with them at all times. And no, I don't think that you can give a checklist to the doctor. And I believe there's even something in the statute that says you can't require that the doctor sign an affidavit. I'd have to go back through the statute, but I don't believe that you're even allowed to do that at this point.
If required documentation is provided that a person needs an ESA, can this apply to one who desires to foster dogs? Thus, multiple dogs are an ESA to a person with disabilities.
I mean, I understand that question because potentially a foster animal is temporary. That's one of those issues that like the statute doesn't address it. I would tell you that if the person has the proper documentation, I mean, fosters can turn into adoptions. A foster could just be that the person wants to see if the animal alleviates their disability. I don't know that how the dog is owned is really a determining factor. I haven't seen that, it doesn't say that in the statute. Doesn't differentiate.
Are all associations HOA owners subject to FHA laws?
FHA is a guideline. Okay, you have HUD as guidelines, and then you do have federal fair housing laws. That is true, and then some states like Florida, or most states, I can't tell you what's in every state, has their own version of those laws. The statutes that I put in here are Florida's fair housing statute when it comes to service animals and emotional support animals. Most of it is based on the federal law. But yeah, I guess arguably someone could have a federal claim for discrimination. Some of the guidelines we look at, because that's how fair housing, like what they rely on when deciding how to look at these cases. So yeah, I would be careful. I would tell you that you certainly could be subject.
This is this is our last question. And I'm going to preface this that this is a common thing that you and I talk about. Does the HOA or the board have the right to contact a doctor to confirm the documentation is correct?
You know, that's a good question. There's nothing that prohibits it. I will tell you that if you're calling, first of all, the doctor may not tell you anything because of HIPAA. Okay, so the association isn't bound by HIPAA, but the doctor is. So the likelihood is you're going to call and the doctor is going to be like, I can't tell you anything other than to confirm I'm licensed. You certainly can look the person up. You can look them up probably under their license. You can go to their website, confirm that they're actually a licensed practitioner. Maybe you could call the office to confirm that the person is actually there and a doctor and a licensed practitioner. But I think when it comes to specifics about their patient, I don't think you're going to get any information. So I think the doctor would be violating their confidentiality with their patient by confirming anything with you. The doctor's note is supposed to be sufficient on its face.
So I guess the reason why I saved that question for last, Lindsay, is because I just wanted to state that as board members and as property managers, we're not attorneys. We don't play them on TV, even when you're watching The Good Wife. But the important thing
in real life.
Yeah, the important thing is that when you have doubt, you don't answer the question yourself. You speak with your legal professional who is retained by your association. So if you're one of my clients for our office, we would speak with Lindsay and we would, get the best answer. Don't do something on behalf of the association that deep down in your stomach is incorrect. If you think that someone contacting your doctor is the wrong thing to do, don't do it and ask for help first. These items are not the same thing as, writing on a piece of paper in the wrong color, you'll fix it later. There's specific policies, specific procedures that we need to follow to ensure that we don't get the association into trouble, to make sure that the boards don't get into trouble. So Lindsay and our last session was all about association documents. And this kind of follows the same process. Don't try to amend it on your own. Ask for the help you need before.
And Jill, if I can piggyback onto that, I think that in a nutshell, it's good to understand this. I think anytime you sit on a board or you're a manager, it's good to understand these issues. But if there's one thing that you get out of here, and the safest thing to do is you don't do anything at all. If you get a request or someone even brings up this subject, these are one of those things that go straight to the attorney. I don't think the board should play detective. I don't think the board should be reaching out to doctors. I don't think the board should be asking for additional information. I think that the second you get a request like this, you send it to the attorney, ask if the letter is sufficient, ask if you could deny it, ask if you can approve it. Is there anything else you can ask for? Every situation is different. There are a lot of things in association law that can be fixed. Okay, there's not very much that on the back end we can't, as attorneys fix. But you discriminate against someone and you handle this wrong, it costs nothing for that person to go to the state and file a complaint. So understand that. With other things, when we're denying rentals or sales, or we're getting in a dispute with someone, we try to take into consideration what's the likelihood that this owner is going to go out, spend their own money, hire an attorney, and fight the association. And it's rare. I mean, it happens, but it's rare.
Right.
This requires zero. Our taxpayer dollars pay for it. They will call Health and Human Resources, which is like the fair housing. It is free for them to file a complaint and the state will run with it. And there will be nothing you can do. And if they think that you are wrong and they have asked for some kind of financial relief, you could get hit with the fine at the end of it. And I will tell you that once it's in their office, because I've had several that have been in their offices, you even if you approve it after the fact, that doesn't mean that they will drop it. So you got to be careful.
Just remember,
it's unfortunate because a lot of people do take advantage of this process. I'm not going to sit here and tell you that I don't think that people submit these and lie. Absolutely, I think that some people do. I also believe that if someone really wants to have a pet, why are they buying in a no pet building? There are a ton of other buildings here that you could go and buy in. I think you are going to start to see as time goes on. Most of the no pet buildings are buildings built in the 70s, early 80s. A lot of them are along the ocean. I think you will start to see over time that there will no longer be a thing as a no pet building.
Everyone just remember that certain items within condos and HOAs are not self-help. Changing your association documents is one of them, and ECA animals is a second one. So just remember when making these choices to make sure you get the proper help that you need.
And by the way, if you don't want to deal with these issues and you're a building that really doesn't have an issue with pets, amend your documents and allow pets. Let the owners decide if they want to have pets. Just because 40 years ago a building didn't want to have pets does not mean that a majority of the people living in your building today now don't want to, maybe they want to have pets. And that is something that should be up to the owners. So that's something to consider too. And that would save you a lot of money because then you most likely wouldn't have to deal with service animal and ECA issues unless there's like a breed or height restriction or weight restriction.
Thank you so much to both our panelists today. It was definitely a very educational webinar, and we are excited that we have to teach more board members and CAMs around the state about emotional support animals. As always, if you have any more questions, you could always contact either Ms. Raphael or Ms. Koch. Their emails are here on the PowerPoint screen itself. On behalf of Raphael Law and Vesta Property Services, we thank you so much for being here with us for the hour today in the morning. And we thank you so much, and we all hope you have an amazing day.
Thank you so much for having me.
Thank you.
Thank you.
Okay.
We're going.
Bye.